Hey, right, everyone. Just bear with me whilst I do the usual stuff in the back of YouTube for a second. I hope you guys all had a reasonable Easter break and didn't have to think too much about housing issues over the 4 days or whatever. Um, that's all done. Hold and bear a sec. Cool. So just to warn you guys who are watching live, we've got two questions that are coming through the week. So unless you're quick to put questions into the live chat, we might we might be finished by like 20 to 8. As always, this ain't legal advice. We're going to do our best here to be helpful and give you some information which will hopefully help out. But obviously, it's limited by the information we can communicate over YouTube and also our own limitations of knowledge. And also, don't ask questions in the first person. So just ask them as a what if question. So what if someone was in this situation? What would the law be about that? That's how you get the same answer, but without having to share your data everywhere. And as always, if you want to give the video a like and a share, whatever, that'd be awesome. If you're not subscribed, you'll get notifications if you are. So let's get on with it. So I feel like I'm not even going to do it. There's basically a bit of a news story this week or the week before where they looked at how long it would take councils across the country to empty their waiting list, for want of a better word, to house everyone on the waiting list. And as you might not be surprised, some of the councils were posting times of over 100 years, which again is just kind of an indication of just how under pressure some councils are. But again, it's also the variation. Now, I haven't yet been able to find the full figures because if I can find them, I'll probably do a video about them. But in a lot of, you'd be surprised by how many places were actually still under 5 or under 3 years. So whereas you got like I can't remember which one was the highest. It wasn't Kingston, but it was one of the London ones. Yeah, say 100 years to clear it. Actually, in a lot of areas, it was nowhere near as high, and it just kind of makes that point that if you're not in London or if you have the ability to apply outside of London, you're probably going to be waiting much less time, and also have a much higher chance of getting social housing. Um, so yeah, any noteworthy stuff from you guys? Newsweek, Pope died, but probably not on topic for tonight. Um, so let's get the questions up and running. Or better do a new document actually. But yeah, say there's two come in. Oh, hold on. Here we go. Question 1B. What's going on here? Sorry, guys. Zoom's been slightly strange. There we go. Yeah, so let's collapse that as well. Question 1. What if someone's in interim accommodation and they've been given a letter with an appointment for a readiness assessment and it says it may impact their current accommodation? Do they mean a homelessness interview? So interesting terminology. I've not heard a housing options interview for assessment interview, whatever, being called a readiness assessment, but it may well be that. I don't know. I'm not quite sure what else it would be. Basically, if a council's accepted someone into interim accommodation, then the time is ticking really for them to kind of make their inquiries as quickly as possible and work out if they actually owe a duty to someone. Hey, you're right, Michael. So I think, yeah, my guess is it probably is, or if it isn't, it's going to look very much like a homelessness interview. I guess they might kind of focus on, I mean, readiness assessment. They're probably kind of using this sort of language to sort of, I don't know, trying to like shoehorn people into a mindset where they're going to, fly off into the sunset or something. I don't know, but I think yeah, they're going to be looking at what kind of accommodation people need, which should be stuff they should be looking at anyway, and that sort of thing. So that's my guess. My guess is the answer is yes. And I'd say even if it isn't, then probably treat it the same as a homelessness interview in terms of taking notes, going with someone who you kind of like is willing to advocate for them. Probably following up with an email with all the information in writing, providing all the information you provide in the interview elsewhere via writing, just to make sure they've got it. You take any information or any documents you have to hand. So things like ID, 5-year address history, usual sort of standard stuff, bank statements. They're all going to ask for them at some point, so you might as well take them along if you can. But yeah, I think other than that, that's my guess. But I'd say whatever it is, treat it very seriously. And bearing in mind, as with all these sort of things, anything you can say can be used, or anything you do say can be used against you in some way. So just make sure that people are being open and transparent, but also making sure that the housing officer's hearing what's actually been said, because that can often be an issue where the applicant's saying one thing and the housing officer's writing down something else. So yeah, I don't know. Have you guys heard of this sort of language been for a homeless interview before? So I mean, yeah, as I say, councils use different terminology, but they're basically probably doing the same thing here. So it's probably going to be a Section 189A assessment, which is that whole question of what led that person to be homeless, what type of accommodation do they need, and what support do they need to maintain it. That then feeds into the PHP, the personalised housing plan. But there'll be other questions in there as well, which kind of pave the way for decisions about priority needs, intentional homelessness, that sort of stuff as well. Local connection will also crop up. But bearing in mind at this stage, any council you approach will have to get to this far in the process before they can start referring you back to a different council, and only do so if it's safe to do so. So yeah, anything to add on that one at all, guys?
No.
I guess the only thing I'd add is like, so I've only ever really heard of like readiness stuff when it's around like supported housing. So it's just being aware that that might be sort of what they're looking at is like how ready are you for a tenancy, but just to like state the obvious, guess, and to highlight, but there's a stark difference between managing your own tenancy in like an independent flat or what have you, and living in supported housing, which is often chaotic and comes with additional rules that um adults otherwise don't have to follow in society. And so just because you're not ready for that sort of like weird setup doesn't mean that you can't manage your own tenancy, and just being aware that that might be the angle there. It might not be, and the person might want supported accommodation, and obviously that's completely justified and stuff. But I'd prepare for that sort of line of questions and stuff, I guess.
Yeah, it's probably not possible in an interview setting like that, but it's sometimes helpful to educate housing officers. Things like, just because somebody failed a tenancy last time for some reason or other, first of all, doesn't change the fact they might have a duty, there might be a duty to provide another tenancy anyway. But also the fact that they lost one tenancy does not mean they can't maintain any tenancy. It's often just related to specific issues that might have happened in the previous accommodation that led them to lose it. So yeah, and certainly that kind of mindset that, they can't manage support accommodation, so they definitely couldn't manage a tenancy. That is polar opposite from what the actual truth is. So if you have opportunity in a situation like that to kind of just, gently nudge the housing officer to actually be, kind of reasonable about this sort of thing and actually kind of base their reasoning on evidence, that probably wouldn't be a bad thing. So yeah, but yeah, there's probably more to say about that, but we'll keep it short tonight. And then this is question 2. So this is a support worker asking it. So I asked the GP the Smith or stroke Thomas question. So that's basically 2 cases which relate to vulnerability, which set out the definition of vulnerability about as clearly as you're going to find it. And essentially it's kind of focusing on what issues does that person already have, how is homelessness going to affect those issues, what harm might they be at risk of suffering because of those issues, and would a healthy and robust person suffer those issues. And if the answer, depending on what the answers are to those questions, I've kind of amalgamated both tests there, but yeah, that's what they're talking about here. So the GP ignored them and sent the patient summary. Is the next best step to do a subject access request? I assume that would provide more detail at least. So yeah, cool. So very common problem by the sound of it, and around the country, because GPs seem to be kind of shutting down, battening down the hatches, not like doing any more work than they have to. Subject access request is absolutely an option. The downside is it's going to take 30 days, and it still won't necessarily, and I think the person asking the question understands this, it won't necessarily actually still provide the information the council actually needs. That will still need to come from a doctor, really. But that's an option. It's not going to hurt, that's for sure. It would provide some more information, as the questioner says. I wonder if, in the situation, a phone call to the practice manager and just basically saying, look, we really need this information. It's really going to make a difference to this person if we have this information. It only needs to be like, 2 paragraphs long. It's not a lot of work. And if you don't provide it, yes, we're going to have to go down the SAR process and kind of get you to provide all the information. Can you be a little, can you reconsider that position? And if they, I mean, the GP might also be, they're at liberty to say, well, we want to get paid for it. In which case, an organisation might have a budget for that sort of thing. I guess it's a bit more difficult if you're just advocating for a friend or something. But yeah, those things can happen. So I think it depends kind of how bureaucratic they are. But it's absolutely in the GP's interest to provide this information, because it will mean the patient's likely going to get housed. that will likely have a positive impact on their health. That will stop the person coming back and kind of having health issues that result in kind of coming to a GP. So yeah, I don't know a better way of doing it. I know Shannon's going to come in a second, but I know Shannon's kind of a big fan of the NHS app as well, as a way of just kind of getting information quickly. But yeah, Shannon, do you want to kind of add to this tool?
That's all I was gonna say really.
Okay.
Was sorry, it can take like a week or so if you're not already set up with the NHS app because your GP surgery needs to okay it and do that sort of side of things. But it would definitely be quicker than a subject access request. And then also you're in control of like what information you're showing them. And again, it might not have, the answers to the Smith and Thomas questions, but it will have more information around your conditions, how many times you've seen the GP, what you've seen the GP about, any medication you're on, all of that sort of stuff, all in one place. And you can screenshot it, you can send it across. And so yeah, if it's possible, I would try the NHS app before doing a subject access request actually in this. Um, just because as well, I think the accessibility of the app is far higher than a subject access request of loads of different doctor's notes that will have the codes and everything else. So yeah, that's all I was going to say.
Yeah, and I guess in this situation as well, like it might be possible to request information from either health professionals or kind of other related kind of support professionals who will hopefully be less difficult about providing information. But certainly, if you're working in an area, it's an issue which you probably want to find a way of raising politically with this, with a small p, not kind of just kind of engaging with politicians and engaging with. I mean, I don't even know how NHS is structured these days. Like the clinical commissioning groups, do they still kind of define? Do they still kind of have authority over GP surgeries? Do they even exist anymore? I don't know where things are at. But whatever the answer is, there will be some sensible people somewhere which kind of influence and have a lot of influence over GP surgeries, and actually having a conversation with them and explaining to them why this is absolutely in the NHS's interest to do this and to provide this information. That's going to be a good thing. So yeah, good luck with that one. Next one, question 3. There's some questions coming on the live stream now. So how you at, Shadow? Nice to have you here. So this one's a two-parter. So someone was owed the wrong housing duty and requested a review. In the meantime, the council is now pursuing a case and offering private rented accommodation under the prevention duty. Since there have been no official offer from the council yet, can the person refuse the accommodation until the review decision is made or receives an official offer? So, oh, interesting question. I just lost my headset there. So I would need to check. In fact, we can check the small print in a minute. My understanding is that you can turn down offers of accommodation in the prevention duty, and there is no bearing whatsoever on the kind of follow-on duties within the relief or the relief or the main duty. So let me get the old premises code of guidance up here and just have a little look at this. I'm gonna take me a moment just to find where it says it. Let's search for the term no consequence. Yeah, I'm gonna. If I have long enough, I'll find this. But basically, I think it says something about that. So I can't remember. I just can't remember the wording of it. So hold on a sec. Let's just have a little look where it might be. Oh, I'm going all over the place now. So yeah, prevention duty. Let's see if it's in here. I actually think it's not in here. I think it's in chapter 16 or something. Let's have a little look. Okay, I can't see it being in here. I'm just going to double check it back up here. So for those who are wondering what the hell this is effectively the rule book for councils. And although it's called guidance, it's statutory guidance. So it's telling councils how to interpret the law. Guys, if you see what I'm looking for, just please shout out. But yeah, I think it might be under. I don't know if it's under ending relief or prevention duty, maybe. So this is okay. It might be in this section here, which is really long. So you kind of got I think the 7 reasons why a council can end the prevention or the relief duty. And I think it makes the point that turning down accommodation in the prevention duty doesn't affect the next steps. Okay, well, I'm not going to find it right this moment, but I'm going to keep looking for it as we kind of keep talking. But there is something in there about it. That's the short answer. So if I can't dig this out in the live stream, then if you look at the code of guidance, you can just Google it. Just Google the PDF and just go to guidance. You get the most recent version, and it just talks about this. And you'll notice how ridiculously convoluted it is. It's ridiculous anyway. But yeah, because okay, here we go. Here we go. Here we go. So you're right. So deliberate and unreasonable refusal to cooperate. So that might kind of kick in here. It doesn't automatically if you're turning down accommodation. So the prevention and relief duties can also be brought to an end as a result of the applicant's deliberate and unreasonable refusal to cooperate. For further guidance, see chapter 14. This is chapter 14, by the way. So this is just an example of where they just weren't looking at what the hell they were doing when they made this guidance. Where the prevention duty is brought to an end due to deliberate and unreasonable refusal to cooperate, the applicant's entitlements under any other section of Part 7, including the relief and main housing duties, are not affected. So what effectively can happen is you're under the prevention duty, they offer accommodation, you turn it down, they can end the prevention duty, but then if you become homeless, the relief duty will kick in. Now, they might actually offer you exactly the same address, the same property under relief duty, and that becomes more problematic if you're going to try and refuse it at that point. It gets basically there are two things you need to be kind of watching out for. That is an offer which is called a final accommodation offer, which will be an offer of private rented, or a final part six offer, which will be an offer of social housing. If you turn either of those two down, you're knackered. That's the end of the process for you. But there will be other informal offers that can be made to look like final accommodation offers, but they're not really. And so it's very difficult to expect someone who's going through the process to actually unpick all this. But what you can do is go to the council and say, look, this is an offer. I want you to put in writing what the consequences of me not accepting it are, and basically get them to put that in writing so you can then make an informed decision. Um, and I guess, as we always say on the live stream, don't, if you don't turn down accommodation unless you literally can't move in, because you can potentially challenge it down the line anyway. Gets a bit messy with prevention duty. But yeah, hopefully, hopefully that makes some sense at least. It's a decent question. It's just this ridiculousness with the prevention and relief duty, basically. So yeah, I'm hoping that answers it. Let me go back to the question, actually see what the question was, just to double check. But I think that kind of answers it. Yeah, so since there's no, yeah, so and again, if there's not an official offer, if it is just literally the council saying, yeah, okay, we've got a private rented accommodation over here for you, that is not an official offer anyway. Because for the council to end the relief duty, because you refuse accommodation, it needs to be a half decent assured short hold tenancy that isn't run by a rogue landlord, that kind of thing. So there are various standards that the council have to apply to. So often councils will often make these offers in the relief duty and the prevention duty of things like supported accommodation, stuff like that. That is never going to be a final accommodation offer because it's not going to be an assured short hold tenancy. I appreciate. I want to go back on that slightly because I know some supported accommodation does actually have tenancies, which would change things slightly. But yeah, generally speaking, they're going to be licenses rather than tenancies, so you can turn them down. But don't take some guy on YouTube saying it. If you're going to turn down accommodation, you need to research it yourself and make sure the council's laid out what the consequences are of not accepting an offer. Shannon?
It's 6 months as well, isn't it, under the prevention duty? When they make an official offer, it's a 6 month tenancy, isn't it? Whereas under relief duty, it's a 12 month. Sorry,
No, no. So
it's a 12 month tenancy.
so no, it's worse than that. So basically, the final accommodation under relief would be 6 months, but then the private sector discharge of the main duties, that is to say, if you're owed the main housing duty, whereas 15 years ago you'd be guaranteed to get social housing, they can now end it with a 12-month assured short hold tenancy. So you can see that effectively the discharge of the duty under the relief duty is not as good as the main duty. So you can kind of see how the Localism Act made it worse because it kind of restricted access to social housing. Then the HRA made it even more difficult to kind of get a kind of a 12-month assured short hold tenancy. So you can kind of see how over time they've made it more and more straightforward for councils to end duties by putting people into private rented accommodation. And in practice, it's very difficult to challenge the suitability and the quality of that, without kind of spending a lot of effort on it, basically. So yeah, we have got no more questions at this point. So I'm going to give it a couple of minutes just in case someone's got an extra question. Will, have you got You
I
coming in
just
there?
wanted to ask a supplementary question on that last one. I mean, at the risk of looking stupid, I was just wondering why would they be making an offer of private rented accommodation under the prevention duty? Because my understanding was the prevention duty is to prevent you from losing the accommodation which you've got. Would it be where you think they've had a look at preventing it and they say, well, we can't prevent it, so how about an offer?
Yeah, yeah. So basically, because it's the prevention duty is not restricted just to again. Let's see. It might be kind of in that first bit of chapter 12, but basically, so they're kind of yeah, the first kind of plan A is to stop someone becoming homeless. But if it's clear that there's no way that the that accommodation that is going to end, that the landlord's serious about it, all the rest of it, before they've even kind of before the Section 21's expired, they could, sorry, get to the right chapter here, they can still look at alternative offers of accommodation. So, let's see where it actually says that specifically, because yeah, this in one sense, this is really annoying because it's not actually very helpful most of the time anyway. So we don't actually use that much really, but it's there and you do still need to navigate it. Um,
Is it
excuse me. So I think it kind of comes under the reasonable steps, which is both either to prevent someone from becoming homeless, or if they can't prevent it, to find an alternative offer of accommodation before the prevention duty actually ends. So I don't know if it's going to say again. It's kind of spread over various chapters, but
okay?
um,
So how long does the prevention duty last then? It's not like the relief duty lasts 8 weeks, yeah?
well, again, it kind of lasts as long as it needs to. That's the answer. So
Mm.
because there are going to be situations which someone might be, they might be threatened with homelessness. Therefore, the prevention duty kicks in, but then the landlord delays something by a month, but they're not going to end the prevention duty just because 56 days are up. They're going to keep extending it
Yeah.
again. But it's yeah, I think I mean the fact you don't know much about this will just shows how irrelevant it really is, because I mean you kind of deal with the nitty gritty of getting people housed, and this doesn't really help many people. So yeah, I'm trying to
I,
see
I
what.
personally
Often,
think the prevention duty is useful, but only in a limited way of preventing people from losing accommodation. And that may be where somebody genuinely doesn't want to lose their accommodation, but they need some help. For instance, I'm just going to make a referral tomorrow, hopefully, to a local authority where there's a person with mental health problems who is being facing eviction due to antisocial behaviour allegations. So I want the local authority to do an assessment to see if there's anything they can do to help avoid loss of his home. And that's useful as well because if he gets evicted and they find him intentionally homeless, we can say, well, it wasn't just him. It was, I mean, you guys could have helped him, but you didn't. Um, So I find that tactically quite useful, but I've never thought of asking for an offer of accommodation under prevention duty. I'd then say, well, are you going to do it? Are you going to accept them as homeless? And then we'll get the relief duty clock ticking.
Yeah, I don't think there's any kind of teeth to it. So I'm just going back. So this is a document which I'm trying to get it to zoom out. Which I've made. So this is not authoritative, but this is something I did like a year ago or so, and I did spend a lot of time on this. So I'm pretty confident that this is correct. So if we just go to this is the prevention duty stage here. So and I think again if we just go down to so if the prevention duty ends, the prevention duty ends if the applicant refuses an offer of suitable accommodation, and on the date of the refusal there was a reasonable prospect the suitable accommodation would be available for 6 months, or if the applicant is deemed to have unreasonably refused to cooperate. This refusal or unreasonable refusal to cooperate does not affect any duties. Okay, so it doesn't actually say it there. I think I'm sure it says it somewhere. Yeah, so if the applicant becomes homeless at any point, the prevention duty becomes the relief duty immediately. So in one sense, in terms of how long it lasts, it will be
Yeah.
defined if someone does become homeless. But I'm pretty sure the wording of the law is that it's kind of like council should be reasonable and kind of keep it open if it's going to be helpful, and they shouldn't just stop it because of certain times elapsed or whatever. Same with the relief duty actually. So although we often talk about the relief duty only lasts 56 days. If you're not owed the main duty, and this is where it gets messy again, but there's nothing stopping a council actually extending the relief duty indefinitely, really, if they think there's a chance of actually getting that person housed or relieving their homelessness. Whereas if you're in priority need, you're not intentionally homeless, they have to make that decision on day 57. So it's a bit rubbish, isn't it?
Thinking it through, actually, in my situation, if somebody goes to the council and says, "Look, I'm in trouble. I can't afford to pay my rent. Can you help me?" I haven't got a notice yet, so I'm not threatened with imminent homelessness, but there is a threat of homelessness at some point. And they say, "Look, sorry, we can't help you. But the good news, that's the bad news. We can't help you keep this place, but the good news is we found you somewhere else, which you could afford."
Yep.
That could be done under the prevention duty because they're not doing it because you're homeless. They're doing it to help you avoid becoming homeless.
Which is the whole spirit of the prevention duty at all. That's why it's
Yeah,
there. So
yeah.
yeah, that I mean that's yeah, the law certainly allows that, although it doesn't make the council have to give an offer in that time. It does that's the whole
But
point of
it's
it
a
really.
possibility, isn't it? And they wouldn't then have to go through doing a 184 notice and accepting a relief duty.
Yeah, yeah, yeah.
But can I just say the other thing is, of course, if they make you an offer of private sector accommodation under the prevention duty, I wouldn't turn it. I mean, I'm not suggesting the person here is saying, "Well, I'm going to reject it on principle because I don't have to accept this." I mean, if it's a nice place and you're happy living there, I'd say go for it because even if you go through right through to section 193, they could probably, I mean, subject to the length of the tenancy and various things, they could get away with offering you the same thing at that stage.
Yep.
So you might want to just look at the end result rather than the how they got there. But if you don't like it, you're in a stronger position probably for rejecting it at the prevent if it's offered under prevention duty.
Yeah. Yeah, yeah, I mean, I think exactly right. I mean, they could basically end the prevention duty and then prevent, yeah, the relief duty starts very quickly and they make exactly the same offer. And then if you reject that, then they can end all duty to you. So, yeah,
There's lots
so
of stuff coming in now.
yeah,
There's more on that question as well. So the person's put Section 21 notice had expired, and the
okay,
landlord applied for possession order in priority need. Applied for possession order in priority need, but accepted the prevention duty instead of the relief duty. Claim form received from the court. But maybe that's where they were saying like someone was owed the wrong housing duty, and that's why they've requested a review because actually they shouldn't be in prevention; they should be in relief.
It should be relief now. Yeah.
Yeah,
yeah, yeah. If the section 21's expired, in almost all cases, it should be relief
yeah.
duty. Um, so yeah, I don't know if our answer is any different from that, other than potentially, yeah, this person shouldn't be under prevention; they should be under relief. And that is worth challenging because, well, yeah, I mean, it's a lot of a lot of the homeless application process. You're in this situation where, as bird in hand is worth two in the bush. You just don't know enough information to actually make an informed decision, unfortunately. And so, because there's so many unknowns in it, and that actually might be where the council's actually trying their best because they don't know where you're going to actually be. They don't know yet. They generally don't know, but you're expected to have to make this kind of decision, which can have a huge impact on your life without actually having access to full information. So yeah, um, okay, where are we up to? This is a multi-parter, so let's get it all together before I start reading it. I think that's it. Hey, you right, Cheeseface? You right, Tiff? Um, person not in temporary accommodation is waiting for a decision under review, Section 202 from the council. The council requested extension, 10 weeks in total review time. Current accommodation not reasonable to occupy. Person has a solicitor helping, strong medical evidence, mental health diagnosis. If a person is successful and is owed the main duty from the council, will the council help to move to another accommodation quickly, or will it be something like PHP, which takes a bit of time? Can you explain this? So hold on. Okay, so basically that says to me that essentially someone's made an application, and there's actually two ways to read this. They made an application and the council said there is no reason to think you might be in priority need, so we're not going to offer interim accommodation under Section 108. Or it maybe they had reason to believe, but now they've satisfied themselves that you're not in priority need. The second one would warrant a Section 202 review. The first one wouldn't. So if the council literally is that pig-headed that they say there is no reason to think you might be in priority needs, then there is no way to challenge that without going down judicial review proceedings, and that means getting a solicitor really. Whereas if the fact there's a Section 202 in play here says to me that the council's essentially reached a negative decision somewhere. The fact that there's mention here about strong medical evidence, maybe, I would say that's most probably about priority need, but it might not be. In fact, I'm telling you a lie, actually, because the person does actually say, so the current accommodation not reasonable to occupy. It might be the actual argument is the council saying that they're not homeless. And so that's what and effectively the issue comes down to a mental health diagnosis and how that impacts them in that accommodation. So that might be what's happening here. So that's going to be my best reading of it. If a person is successful and owed main housing duty from the council, will the council help to move to another accommodation quickly, or will be something like so? Okay, so basically, if the council accept you are in, so if the Section 202 review is successful, as in the council say, yeah, fair enough, actually it's not reasonable to continue to occupy, that at that moment they kind of accepted you're homeless. If there is reasons to believe that you might be in priority need, which probably will be the case here, if you're homeless because your accommodation is unsuitable for your mental health issues, then they should immediately offer you Section 108 interim accommodation then. I don't know. I mean, I'll let Will and Karis kind of say whether there's anything a solicitor could do to speed that process up, in a situation where actually they're being left homeless, whether there is a way of kind of speeding that review process up. So I don't know, Will or Karis, you want to sort of say about that? I mean, just to say as well, sorry, the PHP will happen anyway. I mean, yeah, so the PHP happens in effect once the council satisfied you're homeless and eligible, or shortly afterwards anyway. So that will happen whether you're in interim accommodation or not, or temporary accommodation or not. So yeah, sorry, Will.
Oh, I was going to say, Karis, do you want to go first?
No, it's all right. I don't mind. I was just going to also say your solicitor's helping. They should ask their solicitor that's helping one, but also there isn't really a timeline because, well, I say there isn't really, but they've got text weeks to the total review time. But if the solicitor's making submissions, then they've got to look at the file, look at the paperwork, make submissions. Then the council kind of go back and forth. So it's kind of sometimes it's a bit like how long is a piece of string, isn't it? And there's no, and what I say is that there is no piece of thing, and the council can extend it. We've currently have where some councils are requesting like a 12-week extension on some cases to do the review. So it does depend.
Does the fact that it's like, I mean, because sometimes in one sense, if the person was in temporary accommodation, they kind of, they're safe, they're kind of things are okay. Is there the fact that someone might actually be being left at risk of harm for some reason? Does that change the timeline of that that kind of judicial review process? Can you bring dates forward because there's some sort of urgency on it? Because I mean, in this situation, there might be significant urgency. We don't know, but can that be used to kind of speed the process up at all?
Not the process, but kind of change the situation. So like they'll move them into another temporary accommodation. Like if it's not suitable and it's triggering like asthma attacks and they've ended up in the hospital, or it's not suitable because there's stairs and they're a wheelchair user, they'll move them it quicker. So it doesn't change the time of the review, but it'll change the situation they're in. So in terms of like if there's domestic violence or risk of violence, they'll move them out of the area. So stuff like that, but it won't change necessarily the review. That's if they've been provided accommodation pending a review. Stuff like that.
Cool.
Does that make sense? And if it isn't, if they don't, you challenge it by judicial review, which is sometimes a bit quicker, but it's not an immediate remedy. Sometimes it can be.
So in the situation here where someone's got a solicitor involved, is it just a case of just kind of holding tight and just letting that process run its course?
Yeah.
Yeah.
You can kind of request updates and keep your solicitor updated if anything's happening. And it is a stress because sometimes people are thinking, oh, I'm just going to get evicted because I'm in temporary accommodation. But it's not. You'll still be given that warning, and if they do not uphold the decision or give a negative decision, then it's challengeable. And you kind of just go through a process. But yeah, it would be a case of just sitting tight. But anything that's a problem, you just go back and talk to your solicitor about it.
Yeah. Okay. So there's just some comments coming in, just kind of relating to this whole issues, because we obviously covered a lot of ground quite quickly there. So if I'm just going to share the code of guidance, because this, I mean, this comes up every other week pretty much. 6.35 of the code of guidance, and when the eviction process, at what point does when does the relief duty start? So that's the example here. Someone's saying that the relief duty doesn't start automatically when the Section 21 expires. That is correct, but it likely does. So, because bear in mind, the relief duty starts the moment the council is satisfied you are in fact homeless and you are in fact eligible for assistance. And so, sadly, I mean, I guess fortunately, this is going to end at some point this year, so it won't. This convoluted bit of the law won't exist. It might get replaced by something else, I guess. But so basically, so 6.35, where an applicant is an assured short hold tenant who's got a valid Section 21 notice, so that's the first thing, and the housing authority is satisfied the landlord does in fact intend to seek possession, and there's basically nothing that can be done about that, and there would be no defence to an application of possession, then it is unlikely to be reasonable for the applicant to continue beyond the date, the expiry of the valid Section 21 notice. So that in effect is the point where you first might become homeless. So before that, you're threatened with homelessness, when it is likely you'll become homeless in the next 56 days. And the guidance is pretty clear cut on that bit. But then in most cases, the day after the Section 21 expires, where these criteria are satisfied, then that is when you are homeless. So if the council is also satisfied you're eligible, that is when the relief duty would start. And that is also potentially when the Section 108 interim accommodation duty would start as well, if there is also reasons to believe you might be in priority need. So bear in mind, Section 108 is reasons to believe you might be homeless, might be eligible, might be in priority need. The relief duty basically ticks two of those off already. So homelessness and eligibility is basically decided at that point. So if there is then reasons to believe you might be in priority need. So the obvious example where you've got family with kids, where it's obvious that you're going to be in priority need, then the interim accommodation duty would start at that point. Now, an applicant could elect to stay put and kind of wait in their accommodation. That's legit. They have a legal right to occupy it, but that's not the same thing as being reasonable to continue to occupy the accommodation. So that is when the relief duty should start. Then basically the further down the eviction process you get, the less and less likely it is that you're not homeless in effect. So really the relief duty should start in most cases at the expiry of the Section 21. And then, as I say, if it doesn't kind of kick in here for some reason, or there's no kind of like examples within case law, as far as I know, of saying when it wouldn't. Certainly the LGO is pretty black and white about this point. But yeah, say it hadn't been, but further down the line, then that's when the relief duty would kick in. But again, I just don't know what kind of situation where these three aren't satisfied that the relief duty wouldn't kick in, as in the council wouldn't be satisfied you're homeless.
Could I just check with you there? Are we saying that the relief duty arises automatically, or are we saying it's only when the councils say that they've accepted it?
So it's I mean, I guess it's different from what the councils say. I mean, when the council's satisfied, that's the kind of wording. So
They
if they
issue a
don't,
Section 184 notice accepting a relief duty.
I'm not sure about the actual notice they have to issue at that point.
Yeah.
So I don't know, but certainly, I mean, it kind of begs, kind of leads to the question of, does a council have a duty to, for example, to provide interim accommodation when they say they're satisfied, or when there is actually reasons to believe they might be, they might be in priority need, or so on. So
That's
slightly
automatic,
different.
I think, because you would say if the council have reason to believe, if the reason is presented to the council that the person is eligible, homeless, and in priority need, then there is a mandatory duty. But I'm just thinking that if you say to somebody, I'm eligible and I'm homeless, now you owe me a relief duty, they can say, well, we'll look into it and get back to you. I'm just thinking of when the 8 weeks starts to run.
Yeah. So
And I think it's from when they accept it.
Yeah. I guess it's a little bit the sort of the difference between accepting it and being satisfied are potentially two different things. Like kind of, I know they shouldn't be, but they might be in practice. That's kind of what I'm saying. So there is going to be a short period of probably, or I'm going to go on the LGO decisions again to say 10 days maximum between making an application and the relief duty being triggered, unless there are some unusually difficult kind of inquiries to be made. Let's say there's the person makes an application because they're saying there's disrepair issues, and then they have to get environmental health to go in to kind of establish that. That could take some weeks actually before the council's satisfied. But really, in a situation where the council's already aware of this person's situation, they've already applied the 6.35 kind of category, criteria to that person's case, I don't see any good reason why they would not be able to satisfy themselves on day 2, let's say, that the relief duty is starting. But yeah, I guess I take your point that there
Plain
could be.
devil's advocate, there's lots of bad reasons, like they're useless. And there's nothing. I don't think you could go to court and say, "Hey, you're supposed to have accepted." Well, you could. You could say you should have accepted a relief duty, but what you would really be going there for is the temporary accommodation, isn't it? Because you'd say, "I need 188 accommodation."
I mean, I don't see any reason why you couldn't make the same argument and say, well, I want relief duty to kick in, because the whole point is it's supposed to be actually be substantive kind
Oh,
of
you're right. You're
support
right,
you're having.
actually.
So and again, like where councils haven't engaged with the relief duty when they should have, the LGO has recommended compensation. And again, I use that 10 days because that's one example the LGSEO used, but it's not, that 10 days is not set in law as such, but it seems to be what the
Sorry,
LGO
I
say.
was wrong there because they've got a discretion. It's important if you're not in priority need, they've still got a discretion to accommodate you under the relief duty, haven't they? I mean, they could
I've
find
never seen that
someone.
happen, so I don't know. I mean, they can certainly offer you, they can kind of offer help to get into accommodation,
Yeah.
but I would say that's pretty different from, that's different from having that duty to secure that accommodation's available. So
None of that starts to happen until they've accepted the duty. So you would then want to go to a judge and say, well, look, I've got some statutory rights, but none of them are going to start kicking in until these guys accept a relief duty.
yeah.
Yeah, sorry about that.
Yeah, so again, it's the way the law's been written. It's not helpful at all because
No.
it's these time they're whereas before there used to be that 33 working day time limit on the whole process. The whole relief duty, which is essentially limited to 56 days in a case where someone's in priority need and not intentionally homeless, but in other cases it could extend further than that. And as you say, there's potentially this period at the start of the process where you're in limbo because the council haven't actually made inquiries yet. They're just sort of, and yes, that's not lawful because they have to make timely inquiries, but it's a different kind of case to point to the issue and kind of kind of win the argument, so to speak. Um, so that's my reasoning. I mean, just got someone I know who's a experienced housing officer saying that this. I think I'm just going to try and follow the thread here because it's slightly. I mean, first of all, okay, so there's Andy Gale. Just to say, I'm not Andy Gale's biggest fan. If you know, Andy Gale is someone who advises local authorities and has been caught before advising local authorities to act unlawfully. So if you want to know about Andy Gale, search for the term "Who does Andy Gale work for?" And just kind of see that. So certainly in Bedford, we had some relative fireworks in the local housing committee. I say that because there was no fisticuffs or anything, but effectively Bedford Borough Council commissioned Andy Gale to do a report for Bedford in terms of how do they bring TA numbers down, and some of the recommendations in that report were specifically unlawful, and basically that was outed within the committee meeting, so it got a bit fiery. It wasn't just us raising that issue; actually, it was one of the local councillors. So yeah, Andy Gale's not an authority on housing law, basically. So, but someone's So someone's saying. So I think, and I think I'm just trying to follow the thread here. I think that this person's saying that the relief duty starting is between the Section 21 expiring and the possession order, which I guess I'd agree with to an extent, but again, within the time frame that we can work out from LGSO decisions, I don't think that's very long. I think that's maximum 2 weeks, whereas actually, obviously, that period could be a lot longer. So yeah, so that's what I'm saying. It can be 4 months between expiry of a Section 21 and eviction. I disagree with that to say that that the relief duty, that hasn't kind of kicked in at that point. So yeah,
You too.
I'm trying to. There's a reference to Luton there as well. I'm not quite sure where that fits in, but yeah.
Because haven't we been down that road where before we've discussed this, and the point is that when a valid Section 21 notice expires and a landlord is intending to go forward and not let them stay, then I think the wording in the Code of Guidance is the Secretary of State considers it appropriate, whatever, that they should be treated as homeless.
Yeah, I mean that's so. Oh, hang on, I just clicked the wrong button there. So that's what this. So I'm just checking you guys can see what I can see. I'm looking at 6135, which says exactly that. So the Secretary of State considers where an applicant is these three
Yeah.
conditions, then it is unlikely to be reasonable to continue to occupy beyond the expiry of the Section 21. So that's kind of what I'm saying. That's when
Yeah.
the relief duty is kicking in.
If they are
In most
homeless, then it
cases.
should kick in. Yeah.
Yeah. Yeah. And again, most people in this situation, the council will be already familiar with their situation, because if the person applied, when they first got the valid notice, then the council's got plenty of time to be kind of, liaising with the landlord, working all that stuff out. I don't see a good reason why there would be a significant delay in that relief duty kicking in. It should be, I think, within days rather than weeks or months. Interested to know if there's any kind of LGSCO decisions about that, but I've not seen any. It's kind of it's really it's kind of it's important for a lot of people, but it's so complicated that it's very kind of difficult for people to really even kind of pick up on the fact there might have been a failure, which I think might account for why there's not a whole lot of kind of case law or LGSO decisions on this. So yeah. Right, let me go back to where we were. I think that again, yeah, this is, I'm sure that we'll probably be returning to this next week and the week after, because it's such a common issue. But I think that kind of, yeah, kind of answer that question to as much as we can tonight. Which means that the next question, unless I missed one, is, I think this one here. If someone on ESA was referred to DWP complex team referral, can housing benefit be stopped if aware of DWP CTR? I don't know what CTR means.
Complex team referral.
Oh, right, okay, yeah. And aware the vulnerable person has no income, shouldn't they, or hold on a minute, still pay housing benefit? Bear with me. So I get, okay. I don't know is the answer. I probably want to know where the person's living, in terms of housing benefit and that sort of thing. So if they're still in ESA, I guess they're in an area of the country that hasn't got universal credit yet. I mean, can it be stopped? I think it can be, but there needs to be a good reason for it. I think that the referral, I don't see why that would be relevant to the housing benefit claim. The fact there's been a referral to it, whether there's something else happening alongside it, I don't know. But I don't know is the short answer.
I'm a bit stuck. Why would they have no income if they're on ESA? Am I being thick there?
Or maybe there's some kind of like suspension of the ESA whilst the
Yeah.
referral takes place. I don't know.
I think it depends why the housing benefit has been stopped, but I think what the person's trying to make is a moral argument. Like, this person is obviously vulnerable, therefore the housing benefit shouldn't be stopped. But I don't think that's necessarily enough. Like, the moral argument isn't necessarily enough to actually get the council to start paying housing benefit. It would depend on why they've stopped it. But they can back pay housing benefit if it's wrong. So for this, like, I'd go to a benefits advisor, or like Citizens Advice or a money advice place, and or even like Turn to Us. They have a helpline as well as the calculators and stuff like that. So yeah.
Yeah, cool. Hey, you right, Mandy? Just seeing you here. Nice to have you here. Been a while. So just there's some case law mentioned there, but it doesn't actually say which case. It says case law says eviction is when relief duty starts. I'd be interested to hear what the
Yeah,
case law is,
please
because I say we've just seen we've just read the code of guidance, so I don't see where there's room for that.
name the case. I'd like to see that.
Yeah. So I think that's just follow up to there. Okay. Oh, if someone has a complaint towards a council because the council is discussing corrupt, can the person go straight to the LGO? So, I mean, you can always go straight to the LGO, but they'll probably say, no, you need to go through the complaints process. I think there have been cases where the LGO has got involved earlier because there was a very time sensitive issue. So there was a case, for example, where there was a survivor of domestic abuse who was still homeless, and I guess I don't know if I don't know. I think they just said, well, look, this person's very, very vulnerable. They're not in a position to get a solicitor. We're therefore going to investigate now and not wait until the complaints process is finished. But I've only seen that once. So in most, in certainly most cases, the LJ will expect you to have exhausted the council's complaints process. And I would advise against using language like disgustingly corrupt. I'm not saying that some housing officers aren't corrupt, but it's just you're not going to get you need to kind of focus in on what's the issue, what's your evidence for the issue. If you're going to say that they're corrupt, you need to have very clear cut evidence of that. So yeah, so I think the short answer is you probably have to go through the complaints process anyway. But I think the reality is that some complaints have got a high chance of being upheld. Ones where the person's going in. There's a person who copies me an endlessly to a complaint in the council in some part of the country, and it's just pages and pages of just being furious. And it's like you're doing nothing. The council just basically bouncing it away now. You're not getting anywhere. To make a good complaint, you want to have just very simple bullet points, and really, ideally, it wants to be just very straightforward stuff. Really, I think I just can't see a situation where you're going to be able to evidence that and back it up. And so in one sense, although arguably it shouldn't do or whatever, but the reality is that you're probably the complaint probably loses its strength because of that kind of language, basically. So I think you just try and stick to the facts. What happened, what evidence you have for what happened, why is it wrong? Kind of keep your complaint kind of contained like that. The LGO is not going to kind of give you any more money because something was corrupt. So they're going to just give you money for the kind of the failures that happened. Cool. So sorry, I'm just trying to keep up with things here. So there's just more discussion. I'm not going to comment on all this. There's just more discussion there. Yeah, so Mandy, I'd agree with you on that, basically, or the reasons, the kind of caveats I've said. Cool. Right. So I think that's all the questions as far as I can see. So yeah, so as I say, there's a discussion going on there, but I think there's no questions that are coming out of that. I think that's it then, guys. Unless anyone's got anything to say to that. I don't know. It'd be helpful to have case law. If anyone has got case law on this issue of 6.35, and when do you become homeless? Certainly we know that councils cannot justify, recommend, or advising people to stay put until the bailiff comes. But we're talking about something much earlier in the process here, and it's over. It's going to be the difference of many months. So I think it's probably, although it's kind of not as extreme as being told to wait until the bailiff comes, when the relief duty starts and when the Section 1 interim accommodation duty starts, it's going to have a big difference. It's going to make a big difference to a lot of people. So yeah, interested to hear that case law. But that's it, guys. Thanks for all the questions. You're gone. Well, yeah.
It's sort of like a general comment. I think I make this quite regularly, but it's a call to arms not to be put off. But this stuff that we've been talking about tonight and Part 7 of the Housing Act generally, and also its sort of relatives like the Children Act and the Care Act, these are all so complicated now that what you're dealing with at local government level is people simply do not understand what they're supposed to be doing. Some of the time they will. They know the definition of vulnerability or homelessness, but when it comes to things like what we've been talking about, they're as much scratching their heads as we are. And I mean, without going into a long rant, I've been doing these Section 190 cases which is the rights of people who've been found intentionally homeless but are still in priority need. And where that happens, whether it's children, you'd say that you want Section 190 assistance and also assistance under Section 17 of the Children Act. But the councils I'm dealing with are just demonstrating absolutely no idea. The arguments they're coming up with, like they'll say, we'll assist you under Section 190 in finding accommodation, and we'll even offer you something from our private sector stock. as long as it's not needed by somebody who's owed a statutory duty. And you think, well, that's never going to happen, then, is it? Because there's always going to be. But then they're thinking, well, Section 190 itself isn't a statutory duty, which it is. As far as I can see, it's a duty to assist. But all that sort of stuff. And then one council said, we can't provide you with temporary accommodation while this is going on, which of course they can. You've got to go to children's services for that. And it's just like you think, well, nobody really knows what's going on anymore. Um,
So I came across two cases this week where it was actually almost the other way around, where contrary to what we're talking about tonight, kind of about when the relief duty starts after the Section 21's issued or whatever, there's this kind of or expires. There was a couple of cases where effectively the council had mistakenly accepted the relief duty. And in fact, I think this came up in a question last week or the week before about a flooding in a property. And effectively, the council kind of said, we're satisfied you're homeless, well before they actually would have been satisfied the person was homeless. And I think that leads to the question of, if a council mistakenly accepts a duty, so let's say they accidentally accept the main duty because they literally just don't know what they're doing, they just write the wrong template letter or something. The fact they've issued that letter, does that then hold them to that decision that's in writing, or can they say, oh, we actually made a big mistake there, it's not the case at all, we're going to redo it? I mean, I don't know what happens. I've not seen it myself directly, but that seems to be possible sometimes. So I'm trying to think of the details of when I came across this week. Someone was asking me a question about it, and it was where literally, like, the question was, we're not even sure whether they're even threatened with homelessness yet, and yet the council had written a letter saying, yeah, we accept you're homeless. It might, as I say, it might have been a template letter, and that then actually kind of immediately led to a number of other duties because they were saying they were homeless. So yeah, I don't know what the answer to that is. I don't know if you guys know, but if a council accidentally accepts a duty, are they then beholden to that letter, or can they just basically say, no, sorry, whoops, we got it wrong?
my view, I think, based on there has been case law on this in the past, is if they make a mistake, they can correct it, but it depends what that mistake is. Like if they grant a tenancy to somebody, and then 3 years later they think, hang on a minute, you weren't in priority need. For some reason that comes up. I mean, it's unlikely that they would be reviewing the file. They can't then evict the person because they're not supposed to be there because they gave them a tenancy. The fact that they did it by mistake doesn't invalidate it. Please correct me if I'm wrong, anybody, but if somebody did it fraudulently, if they did a deal with a dodgy housing officer so that they then got that, you could then, I think they could then evict them because they'd say that it was obtained as a result of fraud and therefore it's invalid. But I think the principle with public law is because if the council accidentally wrote me a letter saying, congratulations, we're going to give you £1 million, but they didn't actually pay it to me, I mean, I don't think I could sue them and say, give me them, you made a decision, you're stuck with it, or make a complaint and require them to pay it. So I think that's the my view on that. But one last thing, just to say, going back to my point before, if there's anybody out there in local government watching this and does understand this stuff and thinks it's just me getting it wrong, and I don't want to sound like I know everything because I don't. I'm still working my way through this, but please do set us straight and contribute because I'd like to know what people think. But I still think it's all of this stuff is still out there waiting to be litigated on. Um, especially the 190 stuff and the Children Act stuff. I mean, it's been going on for years, but particularly with the Children Act, there's still the approach of children's services, quite understandably, is, hey, we're not here as a housing agency, and that sort of grumbly approach means that you just get bad decision making. So that's it. Thank you for listening.
That's cool. Thanks, Will. So next week, guys, the live stream is going to be on a Wednesday because I'm not around Thursday, and neither will actually, it turns out. So yeah, Wednesday 7:30. Will, are you doing yours on Monday?
Um, Next
That
Monday.
that face says no. That face is like immediately like,
I
nah.
think I'm gonna try because I keep thinking it's been so long since I did one on a Monday now that I'm starting to think I ought to sort of reboot the whole thing. But I'll try and do something so that we can just even if we're just having a chat, if you guys are around, that'd be good.
Yeah, cool. Yeah,
talk
I'm
about,
around if you
yeah,
are.
we
But
can
yeah,
talk about social workers. I was going to add that today if we'd had time, but um, difference between an NHS social worker and a local authority social worker. So if anyone's interested in that, I'll try and talk about that on Monday. I don't know the answer, by the way.
you know, do you remember that complaint I'm making to the hospital about duty to refers?
Mm.
I need to chase that again. I kind of reminder came on my calendar saying they still haven't responded. So that's on my list of things to do. I'll keep you posted. But yeah, cool, nice one. Cheers, guys. Have a good weekend. Hope this has been useful tonight, and we'll see you next Wednesday, if not on Monday on Will's channel. But take it easy, guys. Thanks for the questions. And we'll yeah, see you soon.